Annie and the team have put together to run during this webinar as well. So we want you to get involved. You can also ask questions on there. There'll be a Q&A at the end of this, so a good 10-15 minutes allowed for that as well. So please use that as well. So on to today, and thank you very much, Annie, for joining us, and thank you for putting together this great panel. So Annie Clift is from Director at Limeslade. Limeslade support professional services for businesses in construction, business development and marketing strategy and support. And yeah, really looking forward to this webinar. I think it's a very important subject and probably become more so in the last year. So delighted to have the experts with us today. So Annie, over to you, and I'll come back at the end, but yeah, over to you. Thank you very much.
Thanks, Nathan. Good morning, everyone. Welcome to this morning's episode of Construction Cast. A big thank you to UK Construction Week for hosting us today. And thank you to everyone for joining us. Before we get started, just a little background on what is Construction Cast. So as Nathan mentioned, Limeslade help companies in the built environment sector to grow their business and grow their brands. And a lot of what we did pre-pandemic was events and networking and hosting and managing events and attending them. And obviously, when the first lockdown hit, we was very worried that a huge part of our business would disappear. And also, you know, we thought, well, what can we do to help during this period? So the idea of Construction Cast was formed, and the first one happened pretty much the week of the first lockdown. And we kind of said to a lawyer and a barrister, and I think we had someone from the construction world who was over in Hong Kong for the very first one to join us to tell us a little bit about what was happening in Hong Kong at the time and what people could expect from their construction contracts in relation to COVID and so on. And then we've started running them every week, and they've kind of carried on ever since. They are now monthly rather than weekly, and we've had some fantastic guests on the show so far, and we've talked about all sorts of things from design and sustainability to contracts and disputes and expert witnesses, and also things like diversity in the construction sector and corporate social responsibility and all sorts of things like that. If you do want to have a look at our back catalogue, if you've not seen a Construction Cast before, they are all over on our YouTube channel, and hopefully my colleague Stuart is in the chat this morning, so he'll be sticking links and things to various useful documents and web pages and videos and things as we go along. So that's a little bit about us. We've got a fantastic panel for you this morning. Do please share comments and questions in the chat, because we do like to have these things as interactive as possible. As Nathan said at the end, we have put some time for questions. So without further ado, I'm going to introduce this morning's speakers. So first up this morning, we have Karen Kirkham. Karen is a solicitor and the head of construction at BDB Pitmans in London. Prior to joining private practice, she qualified as a barrister and enjoyed a varied career, including legal director of the Construction Confederation, where she sat on various JCT committees and in local government. Karen has worked for pretty much everyone across the world of construction, from developers to contractors, subbies, and everything in between. And in 2021, Karen became the new chair of the JCT, replacing Richard Saxon, and she's the first woman to have held that post. Next up, we have Darren James, who is Group CEO at leading specialist engineering contractor Keltbray. Darren joined Keltbray in April 2020 following 30 years with Costain, where he led high-profile programmes for public and private sector clients, often in highly regulated environments across the UK. He's also a board member of the Port of London Authority and director of the Rail Industry Association. Next, we have Paul Darling, OBE QC. Paul was called to the bar in 1983 and took silk in 1999. He's a barrister with leading chambers 39 Essex. Paul specialises in complex cases which feature multiple parties and large teams, lots of materials. He's often brought in at short notice. Chambers and partners who kind of rank all the barristers and lawyers in the world sort of say of him, he's the man you go to if you have a difficult case. He will always come up with an innovative solution and won't give up even on difficult points. Paul's also no stranger to Construction Cast. He has been the guest on one of our most ever watched episodes, where we talked to him about his career at the bar and how things have changed over all those years he's been at the bar, and you can find that episode as well on our YouTube channel or on the Limeslade website. And finally this morning we have Anna Mills with us. Anna specialises in contentious construction law at DLA Piper. She's qualified as a barrister in 2004 and then as a solicitor in 2007. She has a particular focus on energy and infrastructure. The Legal 500 lists Anna as a next generation partner, and some other little facts about her. She's also a judge at construction charity event Expertise Rocks. In 2014 she was featured as Lawyer of the Week in the Times for her pro bono work on behalf of ex-servicemen. And I have to say a special thanks to Anna because she's actually dialing in this morning while she's on holiday. So thank you so much for being here, to all of our speakers. So before we dive in and start having a look at contracts, I think Senna's going to put up a poll for you all, just to get a little bit of a gauge on how we feel about construction contracts and the contracts that we've worked in. So if we can have the first poll up, please. So hopefully the poll's up on your screen and you guys are answering that. And I'm just... Brilliant. Fantastic. Okay, before we look at the answers, I'm going to come to you, Anna. Now, this is a big question, but let's start off where we are. There are various standard construction contracts that are commonly used, and hopefully in the poll we've got a list of a lot of them. I'm sure there is varying levels of familiarity with the various contracts on this call. So perhaps a good place to start would be a very brief look at some of the differences between the most commonly used contracts. What are the key differences perhaps between the NEC and the JCT, maybe even FIDIC if we have a little bit of time? I know it's a very big question to cover in just a couple of minutes. And what are the things people often notice or get wrong?
Thanks, Annie. As you said, it is a huge topic, so feel free to interrupt me if I'm rambling. There are a lot of differences between JCT, NEC, and, for example, FIDIC. But thinking about those that might trip people up or those that people still get wrong, even though they might actually be some of the best known differences, I thought I'd focus on three. So the programme, time and money claims, and fitness for purpose. So starting with the programme, everybody knows that a programme is important, but often the nature of the programme, its contractual status, and the details of when and how it should be updated are overlooked. And I'm going to be bold here and say that every experienced construction disputes lawyer will have come across at least one, probably hundreds, of projects where the programming wasn't done correctly at the outset, and therefore claims for time are more difficult to establish and certainly more expensive to establish. So under NEC, the programme is a contractual document that requires the inclusion of certain information, and it needs to be accepted or deemed accepted, and it's required in order to ascertain the compensation events. In a JCT contract, there's more flexibility. And for example, in the Design and Build 2016, there isn't a requirement for a master programme. In FIDIC, a programme must be produced, but Clause 8 contains incredibly detailed provisions around updating that programme, when it should be done, what it should look like, and what information should be provided at the same time. And in my experience, Clause 8 is very, very often poorly operated, if at all. So quickly moving on to time and money claims, under JCT and FIDIC, relevant events and matters are dealt with separately, with different events giving rise to time and or money. Under NEC, time and money claims are dealt with together under the compensation event mechanism, and it's done prospectively, not retrospectively. One of the big issues that I see faced by parties who are moving, for example, from JCT to FIDIC, perhaps they're moving away from the domestic market and branching into the international space, relates to the time bar provisions under a FIDIC contract in clause 20.1, which will effectively preclude any claim for time and money if it's not made within the stipulated time period. So that's one that, even though it's there in black and white, even though people talk about it all the time, it still trips up even the most sophisticated of clients. And finally, fitness for purpose. I think almost everybody now, due to a lot of good training done by a lot of good law firms, is aware of the MT Hogard case and the issues around fitness for purpose. But people still slip up and at the contract drafting stage. And sometimes it's because they're not used to the differences between the various different forms. So again, under JCT, usually there won't be any express fitness for purpose obligation, but there is under NEC, and there is even more clearly, let's say, under FIDIC. So if you're using the NEC suite of contracts, you can use different options to try to limit obligations to reasonable skill and care, for example. But the biggest issue that I find is that people don't necessarily recognise the drafting in NEC to be a fitness for purpose obligation. And I think sometimes it can trip people up that unless they see those words fit for purpose, they don't understand that they might be signing up to an obligation that's akin to a fit for purpose obligation. And then, of course, in FIDIC, there is express provision for it. It's broader drafting in the 2017 suite than the 1999, although that's still fairly limited. Not very many people are using the 2017 version. But even if you are, and that we have the broader language there, then you still have to ensure that the purpose is correctly and clearly defined in the employer's requirements. So that's my whistle-stop tour, Annie.
Thank you, Anna. That was great, and great to get it in such a short time. Nathan, could we possibly stop the screen share so we can see the speakers a little bit better? Thank you. That's perfect. So the results of the poll then, it seems that most of you use the JCT contract, and a few on the NEC, and 11% have said other, I think is what we've got there. So it seems that the JCT is most common. So great time to bring in Karen here. Karen, you're the chair of the JCT. So what can you tell us about upcoming changes to the contract? Will there be changes made as a result of COVID-19?
Good morning. Just a quick housekeeping point to say, it's contrary to what it says on the poster, I'm not in fact a partner, I'm a consultant. Not that it makes any difference to anybody, but I just thought I'd mention that. I am head of construction at BWP Pitman. I'd like to rephrase that question, and the way that it's probably going to be put to me and has been put to me by a number of organisations and individuals, which is, why on earth haven't you published a COVID amendment yet? So I'll just quickly explain how it is the JCT works, which is relatively slowly because of the need for consensus and the sheer number of people participating. So as people probably know, it's formed of a number of constituent bodies representing consultants, contractors, public and private sector developers, subcontractors. And so for each contract that's actually published, all of those people who have participating people on the drafting subcommittee have to agree an approach to particular legal issues, which then has to be funneled through to the entire suite of contracts, which is now quite a large suite of contracts, including all the ancillary documents. So the quick answer to the question you didn't ask, which is why on earth haven't we published a COVID amendment yet, is firstly, if you're a construction lawyer in practice like me, you probably had to do your own pretty darn quick back in March 2020, and we do that, even though allegedly JCT is not supposed to be amended, but of course we know we all do it. It's a long process, and also it's where individual member bodies are potentially parties to these contracts. Those parties have to be in complete consensus before something can be published. So it's relatively slow, and also those of us who are old enough to remember the bad old days will remember the sheer horror of being faced with a JCT contract, a sectional completion supplement, a CDP supplement, and 18 separate loose leaf amendments. Amen to not doing that anymore. But what it means is that we do try, I mean, there are some exceptions. We have whisked out some CDM amendments when there's been new legislation, but we generally try not to produce ad hoc individual supplementary amendments. But obviously we're considering what we've learned from the pandemic. You don't want to have a knee-jerk reaction. Once again, I'm very old, but I do remember being faced with umpteen amendments to the extension of time provisions of JCT, which were all directed towards a fuel blockade in 2000, which had already happened, and it was never going to happen again, hopefully. And so I recently published an article saying hard cases make bad contracts, and I think they really do. But clearly the contract form needs a pandemic type extension event and or a loss and expense event, and we are looking at that. It will be some time before the new edition is published. Just to be clear, we're getting to the stage now of understanding what we're going to put in it. Then all those template amendments, I think they're generally based on the D&B form, get funneled through as far as relevant to other forms. And then because we have a lot of digital products and the typesetting of the contract is quite complicated with all the footnotes, etc. There is quite a long publishing process that has to be gone through. Things that we're looking at, and to me, this is just as important as the pandemic. I'd like to talk about digital formation of contracts and digital execution of contracts. I don't know what you've all been doing during the pandemic, but I can tell you some nightmare stories. Like, I was acting for a developer, a well-known city firm was acting for a bank, and they made the in-house lawyer for the contractor take delivery of the original subcontracts and copies so that he could personally certify by email to the bank's lawyer that they were in fact true copies of the subcontracts. And we've all had emailing. It goes like this: here is a PDF of this contract. Please print it out double-sided because that's how it's formatted. Please print it out in its entirety. Please sign the entire thing. Please sign the original and send the original signed double-sided copy back to me, and I will effect an exchange. Anything that can avoid this sort of rubbish is great. And I think we've all moved into a situation where we're either using DocuSign or equivalent products, or other parties are asking us to use it, or we're thinking about using it. It's not completely problem-free, particularly for deeds, and anybody who's tried to get something witnessed will be able to confirm that. But we need to think about digital services of notices, digital formation of contracts, possibly something even more sophisticated down the line, such as forming contracts through blockchain. The potential is limitless, and obviously issues to fall like BIM and Revit models. So one of the areas I find most interesting is actually the possibility of digital formation of contracts. We're also looking at payment security with a view to producing a project bank account agreement, which I think is also a very good move. So that's the things I'd highlight coming up in the next couple of years in the full JCT new suite. Obviously here to sell product, but I think it's a very interesting process. And thank you very much, Anna, for being so polite about my contract form. You were very restrained.
Thanks, Karen. One of the other things that was announced last year following some work that us at Lionsgate did with the National Association of Women in Construction and the JCT is that the latest forms are going to be released using gender neutral language. Karen, do you think it's important that we take steps like these in order to encourage diversity in the industry?
I had a debate with somebody who's from Main Nameless at the last council meeting. Some people turn a bit crustaceous and say, oh, it sounds terribly ungrammatical. I think we were talking about how the arbitrator was referred to as they and them, and that it was alleged that it was ungrammatical, which I tried to lighten the mood by saying, how do you know that your arbitrator isn't a gender non-binary person? I would also like to point out that this arises from a deficiency in the English language. If you compare it with French, which has a useful impersonal pronoun, on, one does this and one does that. If we had one of those, we wouldn't have this problem. I'd also wouldn't like to see what happens in American legislation where the whole thing is full of he stroke she, which takes a very long time, sounds inelegant, and neither may serve the purpose in the particular circumstances. For example, if your arbitrator is gender non-binary. So I'm all in favour, but it's quite anybody who's ever tried to change a contract from you and we to they and them will know that it's very easy to miss some reference to gender. So it's incredibly time consuming, but it is well worth doing. And it's not mere political correctness, it's really us catching up with where we should be anyway.
Anna, did you want to jump in on that one?
Thanks, Annie. Just to say that I absolutely agree with Karen. Interestingly, I was asked by a colleague only last week how to refer to a female, so we suspected, sole arbitrator. And I thought that was really remarkable. And I think that just generally speaking, there's a perception that gender diversity, equality, however you want to describe it, has been dealt with somehow and that we can move on and look at other issues. And I don't think that's the case at all. But I echo that it's Karen's comments that it's extremely difficult to start making all of these amendments. But I think we have to think about it, and we have to have some slightly clearer guidelines about how we're to deal with this issue in the legal world. And I'm pleased to say I think we are in an increasingly egalitarian society. So the recognition is there. It's just about filtering that down and ensuring that everything is brought into reality. And I think starting with basics such as contracts is a very good place to start.
It's all very recent as well. You can't ignore the fact. My mother-in-law became a QC in 1990. There were 57 QCs made that year. She was the only woman. That is only 30 years ago. And therefore, the sort of action that we're talking about is absolutely critical, because there has been an awful lot of catching up to be done. It may have been begun well, but there's still an awful long way to go. And if the price of it is a bit of bad grammar in a few contracts, so be it.
Absolutely. Thanks, Paul. So we're going to move on now from contracts, and I've seen there are lots of questions in the chat, and hopefully we'll get around to as many as we can from there when we get towards the end. We're going to take a look at procurement, and I'm going to come back to you again, Karen, to start this section off. How will the procurement of construction contracts change in the future? What are the effects of things like COVID and Brexit likely to be, if any?
At the risk of repeating myself, I mean, yes, it is a hot topic. Yes, those of us who are advising in practice do find ourselves grappling on the drafting level with this. If I could just, at this point, commend the guidance issued by the Construction Leadership Council. And if you look at JCT's commercial website as well, it does actually draw attention to this, and also some possible solutions in the interim as how you might deal with COVID. I don't want to say anything about existing contracts. I think most developers, I'm mostly a developer lawyer, but they've been quite hard-nosed about it not being an extension event or a time or money event. But when you're faced with an contractor now, with whom you need to enter into a contract, the overwhelming impetus is to be fair and to take on board the fact that it might have an effect on the programme, an effect on the cost of the works. I was having a debate with somebody in JCT the other day about whether Brexit and COVID should be bracketed together from this point of view. Believe me, on the ground, when I speak to contractors, when acting to the developers, they always bracket the two together. I think there's some suggestion that somehow the effects of Brexit are more predictable than COVID. Good luck predicting the effects of Brexit. I've had to cancel several orders from things on Amazon that turned out to come from the Netherlands and were never going to get here. So I do fully understand and feel their pain. Yes, we do have to be, perhaps the way in which we're considering being fair with our contracting parties in relation to COVID and Brexit should influence the way that we try to be fair between contracting parties in all other areas of the contract. It's funny that this particular thing, that we're all in it together, that it's causing us to focus on the fact that we are actually all in it together. And as the Construction Leadership Council has said, certainly in relation to COVID, you're cutting off your nose to spite your face if you're hard-nosed with your contractor, because potentially if they go under, you're not going to get your 12-year warranty on your building. So it's a bit pointless, and you have to be nice. So I think that it's interesting in the way at which that kind of debate is possibly going to influence the approach to contracting. I'm not going to hold my breath and expect that price won't be to the forefront of most developers' considerations, but I would hope that debate will influence things. And yes, we all already have our own pet COVID amendments, and yes, some sort of pandemic amendment is going to have to go in. And possibly, I was trying to draft something the other day, and I feel that some of the effects of Brexit are potentially split between not any time and money event, but fluctuations. I must speak to the JST about this, because I was slightly horrified to discover that only one of the fluctuations, because they're so seldom used, is actually in the body of the contract to look at. You have to download the other one from the JST website, which I think tells you all you need to know about whether anybody's using fluctuation provisions or not. So it's interesting how Brexit would be approached, because anybody who says the effects of it are wholly predictable, I don't think that's fair or true when it comes to deliveries, currency fluctuations, manpower, etc.
Thanks, Karen. Darren, I'm going to bring you in now. Thank you so much for waiting while we covered all the contractual stuff. So as Karen touched on, there's material shortages, price escalations, effects on the supply chain from these issues we're having. Are these issues having a large impact on the projects you're involved with? And what are Keltbray doing to mitigate these kinds of issues? And do we think the industry is going to bounce back, or have we already bounced back? Lots of people are saying they're very busy at the moment.
Okay, well, first things first, I think if I take Brexit first, you could argue that we had time to plan Brexit, but it is a reminder that within one generation, a democracy can decide to do quite opposite things. 1 minute join a community to work with, and then wants to be outside it. So that flags up the need to be agile to change, even profound change like Brexit. And I do echo Karen's point that you could argue you could plan for Brexit, but Brexit looks quite different to what people envisage, and it changes quite a bit. So there is a question mark on whether you could really plan for Brexit. But any organisation that had a plan for COVID-19, I would have ever made any money, because I think if you plan for such a big event, you're never going to be competitive in any marketplace. So again, that reinforces a need for agility. I had down some words here. What we have learned from both of those events is being agile and being ready to respond to change. And we've talked inclusion actually in this already this morning as well. Another example of we should be open to change and be agile, but that shouldn't be an excuse for knee-jerk and panic, which unfortunately, when change happens, we quite often move to, instead of being agile and considered and embrace change, we move to panic and knee-jerk. That was a little bit of backdrop. Your specific question was about material impacts. At Kelpray, we're a heavy civil engineering, mechanical and rail and power engineering business. So we are not as exposed to what has been highly publicised in terms of building materials shortages, because we tend to not be involved at the stage where the building fabric is being done in what we call a first, second, generally the heavy civil engineering that goes before it. But we have been exposed to the increased costs of things like concrete and steel and reinforcement. And to give you an example of what's happened, so I was paying £465 a tonne for reinforcement last summer. Today I'm paying £775 a tonne, which is a huge impact, albeit in a structure that might be something like 10 to 15% of the cost. Therefore, we've got to put that in the context too. Material supply issues have generally affected the general building contractors rather than the civil engineers. So, for instance, in our rail business and our power business, quite bespoke material that it's not as if the general public is going to demand and dabble with buying a bag of cement like they do. There's quite some peculiarities there, but interestingly, again, I like the never waste a good crisis opportunity. For instance, concrete. The reason concrete costs because of the cement shortages. But lo and behold, look at the other agenda we've got: reducing carbon. What you want to do with concrete is reduce the amount of cement in it. So, again, I'm a big fan of Newton's third law: for every force, there's an equal and opposite reaction. But when there's a shortage of cement, people innovate and they find admixtures to add to concrete, which are, we've got a particular product called earth-friendly concrete, which uses less cement anyway. So it's interesting to see, again, my response to what's Kelpray doing about it, what's the industry doing about it, thinking about alternative materials. But I think the UK has had to have a stark look at its manufacturing capability. The heavy reliance on importing material has been brought into stark reality with the likes of Brexit and countries, for instance. Look what people did when they manufactured vaccines. They held on to them, and therefore, if you were importing vaccines, you were probably the end of the queue. So, a couple of things there: looking at alternative materials, collaborating with the rest of the industry. If you look at maybe leveling out the demand for certain materials, that helps. So, all of those things have been very much front and centre. But again, because this is heavily biased towards forms of contract. When I go back to my reinforcement predicament, how is that impacting Kelpray? Well, it depends on what form of contract I've got with my client. On an NEC option E, I'm entirely insulated against it because it's a cost reimbursable contract with no paying gain on a target, and therefore I get paid for what I have to pay for the materials. If it's an option C, whilst I'm paid for what I spend, the margin is moderated by the paying gain mechanism, and therefore I'm at risk to a certain extent. Layer on top of that, some contracts have index linked items. Most of the indices do not nowhere near tackle a doubling of price on a particular material because they're in a small number of percentages. On a lump sum contract without relief for those things, it's entirely up our shirt. And therefore it's a big mix depending on the form of contract. Also, depending on client behaviour, there are some clients, despite what the contract said, of being very collaborative in terms of understanding there's an issue, because they don't want the fact that increased. One of the ways we could mitigate the project is by not buying it now and buying it later. So, you know, there's potential time implications on the client. So as my short answer is, we're doing lots of things, and I think some of it will drive us to think better about what we do, come up with better materials, come up with more innovative ideas to solve the problem. And it's a shame how good we are when there's a crisis on. If we did this when there wasn't a crisis, we'd be probably a better industry.
Absolutely. Thanks, Darren. Paul, do we think that these shortages are going to lead to really big disputes in the long run? And what can people do to avoid heading down the dispute path?
Well, of course, there are two situations. One is a contract already. And as Darren has just very ably and clearly indicated, the nature of those contracts is going to determine the nature of the entitlement. You get disputes when people can't agree about what the facts are, what the contract means. One of the advantages of some of the standard forms that they fly around now is whether you agree with them, disagree with them, they do make it clear. So I think in relation to existing contracts, you're very much at the mercy of what was agreed. I myself think that there'll always be some element of dispute, but equally, a lot of them, as Darren has just very ably illustrated, are give clear answers one way or the other. So disputes obviously often come even if there is lack of disagreement, when there's cash flow and things like that. So I don't think you can predict. But I think going forward, you've got two very interesting tensions. One is the tension between the use of standard forms and the desire not to amend them. And I chuckled at Karen said, of course you mustn't amend them, but we always do, which was, if I may say so, the most accurate thing one's going to hear about standard forms. You mustn't amend them, but we always do. On the one hand, with people trying to do bespoke agreements, trying very much to foresee or to allocate risk in a particular way. And I think it all comes back, I'm afraid, to transparency and understanding of what is being sought to be achieved. If the commercial deal or the risk is allocated in a particular way, then it is for the lawyers then to draft the contracts, amend the contracts, whatever it be, so as to reflect that risk. And I think this is one of those areas where you have a tension between the standard approach on the one hand and the bespoke approach, both of which bring their own advantages and disadvantages.
Brilliant. Thanks for that, Paul. And I'm looking at disputes then, because much of your experience is in the energy sector, which is known for being incredibly complex and dispute heavy. So what advice do you have for setting up your projects to avoid disputes in the long run?
In a way, this is a difficult question because the answer is so obvious, and yet mistakes are made time and time again. So again, trying to pick some of, I think, we do training for 2 hours on this topic, but trying to pick some of the key issues. The first is really to reflect what Paul has just said. So if you have the ability to choose, get the form of your contract right. Different projects and different jurisdictions require different contracts. And so you need to figure out which one you want/need to use, which provisions you need to amend, and equally, which provisions you can live with. As one of my bugbears, lawyers who advise their clients to take a black and white position on certain matters, alleging that it's market, but without thinking about whether or not they really need to take that position. And it's not always about winning, and it's certainly not about the negotiating lawyers winning. It's about the client and what's right for that client. And finding a compromise is often very important. And what we do at DLA is the front end and the back end, the disputes lawyers, work very closely together so that the disputes lawyers can advise the front end lawyers of how risks actually manifest themselves in real life. And so where they really do need to be concerned and perhaps where they can back off sometimes. Secondly, I would say, don't put your contract in the drawer and forget about it. It happens time and time again, even with the most sophisticated clients. Operate it and make somebody accountable for operating it. Equally, train the operational team, because I think there's not enough investment in that area. Often you'll find that the commercial team who's in charge of actually operating it has no real idea how it's meant to work or what the key provisions are. So make that investment up front and set up templates, for example, for the notices that you need to set out. You can do them on coloured paper if that makes it easier for people to know which one to send. and also manage your documentation more carefully. So make sure there's a central repository with notices, communications, letters, etc. Sometimes there'll be a shared project server, for example, but I find that the clients themselves need to have their own very clear document filing system, so that in the event that you do find yourself in a dispute or on your way towards one, you're able to actually mitigate that risk before it happens, because you can refer back to the record much more easily. And the final point is just try to keep an accurate and contemporaneous record of progress, and update those programs or ensure that they are updated. Contractors are generally much better at keeping records than employers, who sometimes are under the illusion that they might be able to rely on the contractor's record. Be very wary of that. The contractor's record will represent what the contractor wants it to represent. So make sure, whatever side of the fence you're on, you keep your own records and you can't afford to be lazy. And think around the issue, because obviously during COVID, it's been difficult for some projects. You haven't been able to go to site and take records in the way that you might have been able to. But there are other ways of doing it. You can utilize drones, you can have photography done. There are always ways to do it. So even in circumstances where the situation is difficult, don't give up on some of those basic contract administration rules. It's a very good investment up front.
It's a judgment for you, isn't it? It's a judgment for you as to how much resource you're willing to spend in order to buy off the risk of a problem on a claim. And secondly, it's also now, you have to do this religiously so as to make it a matter of contract administration rather than atmosphere of dispute. Yes. And therefore, everything you say, I completely agree with. And the consequence of not spending the money is that all the time, is that you're then in a weaker position when you come to having a claim, and a more confrontational position as well. So it's a sort of, but again, it's a choice. If you're prepared to take the risk of not being in a strong position on a claim and having a bad relationship if problems occur, then don't spend the money. But if on the other hand, you want to be in a level position, you've got to do the sorts of things that you talk about, Anna.
Thanks, Paul. I think this is probably a good point to bring up our next poll, where we just kind of want to get a view on what you guys, what you guys in the audience think about disputes and how worried you are about disputes, and whether they are something that you worry about, or whether you're not so worried. And so, Darren, coming back to you, because obviously the lawyers in the room are going to give us their their advice on how to avoid disputes, and it all sounds great in theory, and if we all followed their rules, maybe we would have less. But what about when you're actually on projects, your experience on these high profile infrastructure projects? What practical advice can you give that will help people keep their projects on track?
Okay, I'm echoing what Anna said earlier. I'm going to state the blindingly obvious, I'm afraid. It's
getting good living out of that, so don't worry.
First of all, let's be clear on the purpose of the programme. Often schemes, quite mainly politically motivated schemes, the true purpose of the programme is not as well thought through in terms of what its purpose was. I'm going to use a statement that's normally in management speak, start with the end in mind. In other words, you should know how a programme is going to come into use or into operation at the beginning. If we look at some of the more high profile problematic contracts, it's the tail end commissioning and taking into operation that's caused the problem. We're generally pretty good in building the thing, and problems normally come towards the end. Clearly in the more complex infrastructure space, that's a bigger risk than in a traditional built environment space. I would invest more in the pre-construction phase. People quite often think that's wasted money and let's get to build phase quickly, because anything spent before that is wasted money. It's absolutely not. In fact, £1 spent in that phase probably generates a £10 benefit later on in the programme. I would say this, because I'm a contractor, engage the stakeholders early. There's a fear amongst lots of clients, stimulated by, how do I put this? Some of their advisors, that you don't engage the contractor until late, until you've got everything boxed off in a lovely commodity, and then throw it over the fence to the wolves to fight for. That normally ends in tears. But so therefore, I am a big advocate of early engagement. Take the design through to a level of maturity that you can be confident scope is finalised. we quite often do preliminary design that hasn't really ironed out the difficult scope places, and particularly interfaces, and therefore they unravel during a contract that's been drafted to try and cater for that outcome. But there's no contract that is sophisticated enough to deal with an equitable transfer of risk when the scope's not really clear at the beginning. I would say this, wouldn't I? Have equitable contracts that has the risks apportioned appropriately. A number of times I've been told, well, look, we've given you the weather risk because you're best able to manage it. And the last time I looked, neither Coste nor Calpray could ever change the weather. Now, what we can do is deal with and mitigate the impact of the weather in a productive and an efficient way as possible. But those of you that were driving around about 2 days ago, in terms of you cannot deal with things, some extreme weather conditions, and yet I still smile to see well, the weather's best sat with a contractor, and I'm trying to find one that can influence the weather. Another one for me focused on cost, not price. We generally have a fetish that the price is what we're driving procurement towards, whereas generally, no matter how quick the contract, the cost always emerges as being the winner, and therefore And when you have an equitable arrangement where the purpose is clear, people have been involved early, we're clear what the costs are, and we're all incentivized to keep the costs as low as possible, lo and behold, you generally don't have disputes, and we have a successful program. So again, coming back, I know this is fairly heavily focused on contracts. As a contractor, I am a believer in having a clear contract, and I would echo Anna's point, don't put the contract in the drawer. The contract is there to enable the relationship to be clear as to who's accountable for what and who's meant to deliver what. There's a lovely poem by, I think it was Larkin, that said, "Good walls make good neighbours," and absolutely that's true in contract. So, and I think the contracting fraternity, as well as the clients, have been guilty in the past in thinking, oh, well, we don't really need the contract now. We've shook hands. There's an equitable arrangement, and something goes wrong, and all of a sudden we haven't kept the records. It's not clear what the dispute is, and I would echo Paul's point. We quite often have a dispute when it's actually really a dispute. The contract's clear. We just don't like what it says, and we try our best to try and turn that into a dispute, which then unravels. And so I think all of those things. I know they said a lot into like mother good apple pie, but really we know what good looks like, just for several reasons. And if I cite an example, and again I come back to our responsibility for the next generation in terms of climate change and carbon reduction. The government started on an ambitious rail electrification program, I think best part of 10 years ago. Started off being politically motivated, and all of a sudden, Rural Network Rail had to go and procure the largest electrification program that we'd ever seen, having not electrified any of the railway line for 30 years. And through this enormous multi-billion-pound program over the fence to a supply chain that wasn't ready. And lo and behold, we made a bit of a Horlicks of it between us all. And the shame of it all, by the time we got good at it, political will had then changed to, well, we're not doing electrification because it's bad. Whereas at least now we're moving back to, well, if we're going to decarbonise the railway line, it must be electrified, at least where it should be electrified. There's obviously a case of hydrogen trains and things like that, battery-powered trains and things like that, where appropriate, but generally. So we've effectively got to apologise to the next generation and say, we've delayed decarbonising the railway by 10 years. We procured it in the wrong way, not because it wasn't the right thing to do. And, contractors all, and I was one of them, stood up and said, yeah, don't worry, we'll deal with it. And we couldn't. And therefore it needed 5 years of painful developing supply chains and innovation and productivity and how we do things. And right at the end, for instance, we had great examples of where we knew how to electrify the railway in the most efficient way in the world, and beating the Chinese on some productivity KPIs. But unfortunately, it was through some painful lessons learned. So again, even all that is a big long list. I've got a much longer list if we had more time, and I've got all the scars to prove it.
Thank you,
what Darren said is very interesting, and I agree with it all. But it does illustrate one big underlying question, which is what is the nature of the economic relationship between the contracting side of the bargain and the employer side? If what you are after is, both sides are after, is a margin on reasonable cost, 3%, whatever, that's one thing. If, on the other hand, the economic deal is you want to do a fixed price, then screw the supply. Work with the supply chain to get lower figures. Value engineer, get variation, scope and claims because you want to actually make a killing, then your approach and contracts are completely different. And I think, Darren, that what you say is, with respect, completely right, and the way the world is going, but underneath all of this, there is this principal debate as to what's the economic relationship and where the risk and reward lies.
And I'd be the first to say there are certain contracts that are you can commoditize, and the best way to drive value is to throw it into a competitive market. The question that I was responding to more around complex infrastructure, where someone tries that tactic in a very complex environment and it unravels. And what we all, I'm sure we've all had adjudications and arbitrations where the result wasn't quite what we thought it would be, because they're very, very complex situations.
But the reason I picked it up, Darren, was the difference. If you look at this over perspective over time, and look at the way that organisations that we all know and love approach their approach to contracting, we have seen a change, and largely for the sorts of reasons you give in relation to infrastructure and energy. So I think it is, but I think that if the contractor wants to have the scope to make very high percentage profits, contract-wise, you're in a different world to where you would be with what I would venture respectfully to say is the more sensible approach that you were espousing.
Karen, did you want to add anything there?
No, I just want to self-correct a point. And one of my august drafting subcommittee is sitting here and has reminded me that I've got it wrong. And in fact, JCT template is JCT, standard form of building contract, and is scaled up to D&B, not vice versa. But he did say, otherwise you're doing very well. For all I know, the rules sitting there listening. Karen,
it's quite funny because when the D&B first came out in about 1990, no, before then, what your predecessors did was they took the administered form and did some bespoke amendments, and they didn't quite get all of them right. So some of the early cases are explicable by the sort of the welding on the one hand of old old standard form into the new D&B and the employer's agent and all that sort of stuff. So
it was actually 81, not 91 actually.
Yeah, JCT with WCD 81, you're quite right.
Yeah, so although I wasn't actually, I was not quite old enough to have actually been there for that one, but.
Brilliant. So it seems the results of our poll is 65% are worried about disputes. That leaves 35% not worried about disputes. I wonder whether they are lawyers or in the dispute world, or whether they are running their projects perfectly. But before we come on to some questions and comments from the audience, Paul, when these measures that we've been talking about, these avoidance measures fail, for those who are worried about ending in dispute, what advice can you give them for preparing for hearings, and what are the common mistakes you see, and how can people avoid those?
Well, of course, Anna has, I was going to say stolen my thunder, but that implies a complaint. Quite the opposite. Anna has, in fact, given the answer. What you have to do is to be ready. And you also have to have all the material available. You have to also decide what you're trying to achieve. I mean, Darren's right. Adjudication has, many advantages. It also has the disadvantage of being so quick fire, and that can often lead to you thinking that there are things to be obtained that then can't be obtained. So what I would say is follow Anna's advice. That's obviously a good start in every respect. And secondly, know what you're trying to achieve. An old colleague of mine once described disputes as a bit like football, like a tackle in football. If you go in hard, you come out fine. If you do a sort of weak tackle, you end up with a broken leg. So I think don't go into a dispute unless you are serious about it, and make sure you've worked out what you're trying to achieve. And if you haven't got in your back pocket all the things that Anna has told you to, then be aware that you're going to have to trim and manage your dispute in a way that is at least suboptimal.
Thanks, Paul. Yeah, we've got a comment coming now. As a delay analyst, I rely on disputes, but companies which maintain their records stand the best chance of resolving them in their favour. And I think that's very true and agrees with the panel. So I think we've got one more poll, which we're just going to ask everyone how optimistic you are about the future for the construction industry. Whilst you're answering that, I'm going to start taking a few questions from the audience. We're going to try and get as many as we can done, but we've got quite a lot come through, so I can't promise we'll get through all of them. But I'm going to start. We've got a question here for you, Karen, about the JCT Dispute Adjudication Board documentation of 2021, and could you perhaps touch on the introduction of that and what that might mean?
Probably confess that at this point still sitting on my dining room table unread, so I wasn't involved in its preparation. And just to be clear, I'm not actually on the drafting subcommittee, but many august people were. So I'd have to pass on that question because A, I'm not a litigator, and B, I haven't boned up on what the agreement actually says. But I know that it's meant to introduce as much clarity and detail as possible in these things. Whereas those of us who draft disputes clauses as part of a non-contentious practice from day to day, it's very easy to just bung down something and say, oh, well, adjudication will be in accordance with the scheme or with taxa rules or whatever, and not give it a moment's more thought than that. I'm sure that's very ignorant of me, and I probably should be asking my litigation colleagues, but very often on smaller schemes, it's fairly generic, and on larger things, really a lot more attention should be focused on dispute review boards or other bespoke ways of dealing with A, disputes, and B, preferably avoiding disputes.
Thanks, Karen. And the next question that's come in, I'm not sure if anyone in particular wants to take it. So what do the panel see as the dominant risk for deploying different procurement arrangements, perhaps say between FIDIC and JCT? Does anyone have a view on this?
I think they're unlikely to be the choice on the same project, aren't they?
Yes. That would be my view. I mean, that they are wildly different. I think that's it, Karen. You've summed it up, really. If there's something, if the person asking the question could give a bit more clarity to exactly what they're interested in, we can probably answer that in a much more helpful way. That sounds like an avoidance. It's not.
Or indeed a helpful way at all.
Or a helpful way at all.
Thanks, Anna. Paul, I'll ask you this one. Are disputes inevitable because of the adversarial nature of the contracts?
Well, you see, there's an assumption there about the adversarial nature of the contracts, not one that I nowadays accept with anything like the same alacrity as you would have done in the past. I don't think disputes are inevitable. I think if contracts are well drafted and people perform well and there aren't unexpected things that happen, then you won't get disputes. But if any of those badly drafted contracts, people underperforming or unforeseen events, then they provide the breeding ground for disputes. Let's face it, disputes are nearly always about money, about how the money is going to be shared out. And if you sorted that all out in advance and nothing goes wrong, then you're not going to get a dispute. Now, I myself think one of the interesting questions, I know not everyone agrees with me about this, is the impact of adjudication upon this. I mean, I know that adjudication is about disputes, but going to adjudication is nothing like the hostile, aggressive act that serving notice of arbitration or going to court used to be in the old days. And I think that adjudication has meant that disputes have gone. There used to be this clear distinction between the contract on the one hand and the dispute phase on the other. And very often you have long arbitrations. When I drive through a particular part of South London, I can't ever forget the 4-week arbitration I did about an M&E project that was worth tuppence halfpenny. And every day we went for four weeks to the arbitration. And now that has gone from being the nuclear dispute to one up from, and I accept the one up, and how far the one up goes is an important question, one up from contract administration. And therefore, I think the disputes, if by disputes you mean adjudication disputes, then I think they are an integral part of it, because in one sense, there is, as I say, one up from contract administration, rather than the nuclear involvement of a third-party arbitrator or court process that could go on forever.
Just because it's fun, Paul, I'll play devil's advocate here, because I've said this publicly many times before, but I'm not a massive fan of adjudication, but it might be partly to do with the kind of projects that I deal with. Because I think it does work where you say there's a project and perhaps the value of the dispute isn't that big and it is about somebody getting paid and allowing the project to continue. But I don't think it's fit for purpose when it comes to hugely complex projects where the amount in dispute is enormous, where people need to try to engage experts to produce expert reports that would normally take months and months to prepare, and they're asked to do it in a matter of days. and inevitably people just feel that they've had to pay out, and the whole dispute process has been prolonged because it's inevitable that one party is not going to be happy with the outcome. But that,
I completely agree with you, and of course I've now had a noise off in the way that you thought you were going to, so it's me with the noise off rather than you. I actually think that adjudication, and I'm afraid it's a heresy to say it, but adjudication has many, many flaws, and the bigger the case, the bigger the flaw, in my view, and we could have a very interesting debate. But one of the mitigating factors of what you just discussed, in my view, accurately, is that it doesn't, an adjudication with all those problems doesn't do the relationships as much harm as the 12-week arbitration. And I think that's one of the things to feed in. And I'm an adjudication skeptic. I was involved in the Citibank adjudication, which is the one that I think was probably the tipping point to where the adjudication, which lasted for 6 months, it effectively became a mini arbitration, but without all the advantages. It was an enormous project. It went to court 3 times thereafter. Now, that is all just madness. But equally, the fact that people do have a mechanism for sorting something out which doesn't involve the nuclear option, I think has an advantage. And the key to it, which was what I think you were saying, is that adjudication ought to be confined in ways that means it's used for the disputes it works for, and not then used for the disputes where you and I know that you're wasting a lot of money and not getting the reliability of answer.
Yeah.
Thanks.
Sorry, Annie.
No, of course. And we've had some comments in again. So one comment says, so those suggesting lawyers cause disputes, I disagree. Instructions come from clients and not the dispute itself. Dispute avoidance is in the lawyer's interest. And another comment which says, we spend more time untangling the disputes than we would if we'd done it properly to begin with. So I think those are good points. We are getting very close to the end of time. We have got lots of questions that we've not got round to. Hopefully you'll be able to pull those questions off and perhaps see if we can get some answers to them to people afterwards. Just on our final poll about how optimistic people feel about the future of the industry, 78% of our audience are optimistic about the future. What are the panel's final thoughts on this kind of question? Are you optimistic? Do we think things are going to go better, go worse? Maybe come to you first, Darren, on what you think the future holds very quickly.
Yeah, look, the reality is we've been through a global pandemic and we've all had pretty big impacts in our lives, and we're going to have to live with COVID for a bit longer too, and who knows what COVID-22 might look like and things like that. So I think we've learned some stuff. And we're questioning, the relevance of the office, and we're questioning the relevance of the value of remote working. We've fundamentally questioned the value of some roles people play in society. And you look at the value of thankfully, the medical and nursing profession now, a bit of what we probably used to think of it beforehand. So there's been some profound, I think, reflection points. But look, again, I come back to my fetish about Newton's third law. We will bounce back. We will come up with innovative solutions to deal with things that we've been impacted by. So, and we'll learn to live with COVID. We'll go on a crusade to reduce carbon. And yeah, I'm very confident that we might not bounce back to exactly the same place, but we might bounce back to a better place.
Thanks, Darren. Karen, do you want to chime in on your thoughts for the future?
Well, I often say the sentence, if I was an optimist, I wouldn't have become a lawyer. But I do feel cautiously optimistic about the impact of the last few months on the industry, because I think what it's thrown into sharp relief, and I did mention this earlier, is that perhaps relationships are more important than we thought they were, and that perhaps the relationship matters more than what words are written in the contract, and that perhaps if the words in the contract could reflect more of that relationship. Do I think contract forms have a role to play? And yes, I do, because if you look at some of the things that JCT does, they're definitely trying to influence or set a standard for good practice. I'll give you my concrete example of that is a lot of people think that it's a 5-day pay less notice in legislation. It isn't, and you'll see a lot of a lot of forms that have like payless notice served not less than 30 minutes before the final date for payment ends. A lot of people think that it's 5 days because JCT set that standard and it's been received as a good standard of behaviour in the industry. We do have a role to play as originators of contract forms, and I am optimistic that people will consider the value of their relationships that they've got and reflect those in the bits of paper we all use.
And Anna, coming to you.
Very optimistic. So I say that for some of the reasons that Karen's mentioned. So I've seen a real drive to improve relationships on projects. I've also seen the market bubbling. I mean, particularly in certain sectors, you know, like renewable energy sectors, for example. And I think because people like a challenge and nobody wants to be ground down by this. And so it's in, you know, politically, there's a huge drive. But it's also that is then reflected by the supply chain. They don't want to lose. They don't want to fail. They want to bring everything back to life. And so from my experience, I've seen a huge number of deals happening and a huge fight. Not that I'm saying that people were lazy beforehand, but I think they'd reached a sort of status quo that they were happy with perhaps, and they were just trundling along and business was okay and it was good. Now I'm actually seeing people think, right, we've got to survive here and we've got to do this bigger and better. We've got to show that we can overcome adversity and learn from it and take great strides forward. And so that's what I'm seeing, and I'm really pleased about that. And so I feel very, very positive about the future.
Thanks, Anna. And finally, Paul, your final thoughts?
Yes, well, I'm very, very, very optimistic indeed. As somebody who has been doing disputes now for 30-something years and still doing them day in, day out, I've seen a very big change, and a big change recently. And that is in terms of the skills and competence of middle and senior management across the industry, and the use of the sorts of processes that Anna was talking about. If Anna had come to a conference 5 years or 10 years ago and said what she just said, it would have thought some of the stuff she said would have been thought to have been revolutionary. Now it's orthodox. It's being implemented by the industry, and they are doing so with enthusiasm and competence. I don't want to make Darren blush, but the fact that the industry has many people like Darren with their skills, commitment, and analysis is one of the reasons why I think we can look forward to the future with great optimism.
Absolutely. Thank you very much. And great to end on a positive note for the whole construction industry. Well, that's it. We've almost managed to keep it within the hour, just about. Nathan's just jumping on. There's not much left to do than to thank all of our speakers for joining us today. I don't know about you guys in the audience, but I thought that was a fascinating discussion. And so thank you all so much for giving up your time to be here. If you do want to attend more events like this online and hopefully very soon in person, you can sign up to the Lionsade mailing list. Hopefully Stuart will put a link to that in the chat, or you can head over to lionsade.com to find out more about that. And if you do have any more questions, like I said, I'm going to try and get some answers to some of the questions we haven't got to in the chat. But if you do have any questions for the speakers, or you would like to get in touch with the speakers, you can get in touch with me at annie@lionsade.com, and I'm always happy to put you in touch with these guys and get you. So that's it from us. Thank you very much. I'll pass back to Nathan now.
Okay, brilliant. Thank you very much, Annie. That was excellent, and thank you to all the panel for joining us today. Really enjoyed that, and we've got lots of people on here. We'll pass on all the questions to you, Annie. So you know, hopefully some people can get some answers from that. And just a quick note to say, look out for an email or notifications on Monday. We're going live with registration for Construction Week in October. So hopefully we'll see everyone in person there at the NEC, 5th to the 7th of October. We can't wait to get back to face-to-face. So thank you very much, everyone. And hopefully we'll see you there.
Thank you.
Cheers. Bye.
Thank you. Bye.
Bye-bye.